Hello and welcome to this general talk about bringing a claim for judicial review. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers, and in this talk I'm going to be dealing with a variety of things relating to bringing a claim for judicial review. I'm going to deal with the purposes of the civil procedure rules under which you're going to be operating if you're bringing one, the forms you may need, the concept of calculating time under the procedural rules, how long you've got to do things in, the concept of serving a document, getting a document to the other side and how that's calculated. I'll say something about the parties to proceedings. I'm going to say a few words about being a litigant in person in this area. I'm going to talk about the duty to make full and frank disclosure, how to address the judge, and then I'm going to say a few words about making sure that the administrative court is kept informed of your whereabouts. So in this talk I'm going to be dealing with some general aspects of judicial review. What we're going to do is work our way through the Administrative Court Judicial Review Guide of 2016 in certain respects. It's an essential download. I've given you the link on the slide and also on the accompanying comment to this video. I'm not going to be dealing with funding or vexatious litigant orders. I've given you the paragraph numbers for those in the video itself. As this talk is going to be dealing with the procedure rules, it's worthwhile starting with what those rules are for the court and what their overriding purpose is. If you get an idea of this, it'll help you to make decisions as you go along. So all courts, all civil courts in England and Wales, apply the procedure rules which are set out in the civil procedure rules. These have an overriding objective or core purpose. The court must deal with cases justly and proportionately, including at proportionate cost. So remember, when you're trying to make decisions, the court is to deal with the case justly, but also it has to be proportionately, and that means you don't use a sledgehammer to crack a nut, the old saying. That concept includes acting at proportionate cost. So for any step in the proceedings you've got to ask yourself what's at stake in the case, or how much is at stake in the case, and is it proportionate for a party or for the court to take a step for the amount that taking that step is likely to cost. In the course of dealing with your case, you'll see reference to rules and practice directions. A useful way to think about these is that the rules tell you what you must do or what you can do in the course of a case procedurally. Practice directions, on the other hand, tell you how you go about doing what you have to do, or how you go about doing what you want to do within the rules in the procedure of the case. So the principal rule for judicial review cases is Part 54 of the Civil Procedure Rules, and there are accompanying practice directions. 54A deals with general judicial review practice, so have a look at that. 54D deals with where you can bring your claim, the venue for claims. There are special rules relating to planning cases, so if you've got a planning case, have a look at practice direction 54E. Inevitably, you're going to have to deal with forms in your judicial review claim. Practice direction 4 under the Civil Procedure Rules lists the forms that you'll need to get or to know about. So Form N61 is a very important one, the Judicial Review Claim Form, and there are various others that I've listed on that page. Similarly, you'll need to know about these forms, the Certificate of Service, N215. You may need to make applications, and if you're going to make an application, you're going to need Form N244. And there are various other forms which you can see on that slide, and indeed get the forms off the Administrative Court's website. The rules often require you or permit you to do something within a certain period of time. So how do you calculate time? Under the rules, you'll see references to a day or days. Where you see this, it's a reference to clear calendar days unless otherwise stated. So if you're calculating a time limit, every day, including weekends and bank holidays, will count, except for the day of the act or the order itself. So suppose, for example, that a notice of application has to be served at least 3 days before the hearing. Suppose the application is to be heard on Friday the 20th of October, well then the last date for service is Monday the 16th of October. However, if the specified period is 5 days or less, and it includes a Saturday or Sunday or a bank holiday, Christmas Day or Good Friday, then that day doesn't count. Finally, I want to mention fees. You're going to need to check if you have to pay a fee to proceed to the next stage of the claim. You can find out about these on the Administrative Court's website, and you can see the point at which a fee is needed from looking at that website. You may, on the other hand, be entitled to fee remission. You can apply for this on the website I've given on this slide, or you can get hold of form EX160A. Under the rules, you have to get documents to somebody else, and you'll see reference to the concept of serving a document. So you serve a document. When it is needed, service is deemed to have taken place 2 working days after the date on which the document is sent. So you can't argue that the service of the document only takes place when you receive it, and this is because the same rule applies. Service is deemed to have taken place 2 working days after the date on which the document is sent. So if the document needs to be served and it's sent on Monday, the deemed service has occurred on Thursday. In practical terms, you're going to be dealing with the Administrative Court Office for most of the time when you're dealing with the Administrative Court. So deal with them. Don't write directly to the judge. Write to the Administrative Court Office for the attention of the judge if you feel you have to write to the judge. Note the opening hours of the Administrative Court in which your case is based. The London office is open to the public from 10 AM to 4:30, so it's not normal business hours. And it's not open at weekends or bank holidays, at Christmas or Good Friday, and there may be an additional day's closure around Christmas. So it's worth checking the opening hours of your local place before trying to visit. I want to turn now to who the people involved in the case are. Obviously there's the claimant, but this could be an individual, a company or an organisation or group, and they're the challengers of the decision which is taken by an administrative authority, so that's a public authority of some sort. The defendant in the case is going to be the public authority whose decision is being challenged. And sometimes you'll wonder how to describe the defendant in the case. For government departments, it's going to be the Secretary of State for whatever department was responsible for the decision. So you've got the claimant and defendant, but there can also be interested parties. This is anybody other than yourself and the defendant who is directly affected by the decision or omission. If there is such a person, they must be included in your correspondence before the claim starts, the letter before claim, which we're going to look at later on, and they must be served with the claim form. Interveners is somebody who's applied to make representations or to file evidence in judicial review proceedings. So this can be any person. However, they have to justify being involved. They have to apply to be involved, and they have to act quickly to get involved. They bear some risk of having to pay some of the costs if they do intervene. These will be people like, say, a national charity or a national body like the Equality and Human Rights Commission, who may want to help the court to reach a decision. I want to say a few words about litigants in person. Even if you're a litigant in person, the civil procedural rules apply to you, and it's very important for you to understand that. They apply to you in the same way as they apply for represented parties, although the court does try to ensure that you're treated fairly, and the representatives on the other side, the lawyers, have a professional duty towards you to treat you with consideration and respect, and to make sure that you're not disadvantaged by a lack of knowledge of the procedure. They will still represent their case, and they will put their client's case forward as best as they can, but they should ensure that you're not disadvantaged by a lack of knowledge of the procedures. However, it is much better for you to get to know the parts of the civil procedure rules which affect your case, and in doing so you'll be able to make much better decisions about your case in the long run. You've got a duty to make full and frank disclosure of facts and information. So it's a duty essentially to be candid with the court. For example, you've got a duty to provide to the court and to the other side or other parties all relevant information and facts. This includes documents or facts which are damaging to your case. So the best way to think about it is that there's a duty to be open, honest and frank, and to engage in plain dealing. What this means in practice is that everybody's got to bring all relevant matters to the attention of the court, and obviously must not mislead the court. So nobody must misrepresent the law to the court. That means you've got to tell the court about any relevant law of which you're aware, if it's applicable to your case. In an application which is made without full notice to the other side, you must disclose any facts or other matters which might be relevant to the court's decision, even if they are adverse to your case, and you must specifically draw the court's attention to those items. I want to finish off with a couple of tips. One relates to something that causes litigants in person a lot of worry, how you talk to the judge. My recommendation is that you refer to the judge as my lord or my lady, and if you're trying to ask them to do something, the simplest way of remembering how to speak to them is basically to say something along the lines of, can I ask my lord to go to page, whatever the page number is, or if they've referred to something my lord said, such and such. Don't overdo it. You don't need to put my lord or my lady into every single sentence that you speak to the judge. You don't need to copy what some barristers do, which is to overdo this kind of deferential talk. Essentially, don't worry about it. The judge is interested in getting to the bottom of your case rather than whether or not you're using the right type of language towards them. There is a procedural judge in the administrative court known as the master. That's the judge who deals with the procedural issues if it's necessary to have that type of hearing. You address the master, unsurprisingly, as master. However, you're going to see who you're going to be heard by from the way in which the case is described on the notice outside the hearing room. And if it's going to be a judge or the master, this will be clear from that. But if you're in any doubt, the usher can help you with this. They're very helpful, and all you need to do is just ask and they will help you on this point. The other point I want to finish this talk off with is just a comment on your address for documents to be served on you. Please remember, this is where the documents from the court and the other side are going to be sent. It has to be an address within England or Wales, and the other point to always bear in mind is that if you move, tell the court, because otherwise you're not going to receive the documents that you need.